The Supreme Court has just unleashed a judicial shockwave so powerful that it has shaken the very foundation beneath Donald Trump, leaving the former president and his entire legal team reeling in apparent paralysis. What we are witnessing is a historic inflection point that virtually no one saw coming. And for the Trump camp, the consequences are nothing short of dire. Before we dissect how this legal blow was delivered and why emerging reports suggest Trump himself is spiraling into panic, take a brief moment to subscribe, turn on notifications, and hit the like button. If you are looking for unfiltered analysis of these courtroom battles, details the media often minimizes or ignores entirely, you are in the right place. Join our rapidly growing community now so you do not miss a single development as this unprecedented 72-hour countdown begins. Now let's examine the architecture of this devastating ruling. In a move that legal scholars and constitutional experts are already calling extraordinary in the history of American jurisprudence, the Supreme Court has ordered Donald Trump to immediately, without delay or obstruction, hand over financial records, internal business communications, and highly sensitive documents that even members of his own legal defense team reportedly did not realize were within the court's reach. This was not a routine denial of a secondary petition or a procedural dismissal. This was the highest court in the nation tearing away a veil to expose something hidden. A sealed grand jury investigation has been operating in secrecy, running parallel to every known prosecution for more than a year. Trump is now legally compelled by the Supreme Court to hand over evidence that could reveal an entirely new and previously concealed layer of criminal exposure. It is almost impossible to grasp that the Supreme Court was able to conceal a proceeding of this scale for months without any public awareness. What unfolded was a covert legal confrontation carried out entirely behind closed doors, a silent battle so deeply hidden that even Trump's lead defense attorneys were reportedly unaware of its existence until the ruling was finally delivered. The justices issued this decision without a single hint of advance notice. There were no televised oral arguments, no media advisories, no press briefings. Trump's communications machine was given no opportunity to shape public perception, and his legal team had no time to prepare a response or defensive narrative. In one instant, Donald Trump believed he had fully charted the legal threats surrounding him. He was confident every risk had been identified and accounted for. In the next instant, the ground gave way beneath him, dropping him into a legal abyss he did not even know was there. This development is not simply about piling yet another case onto an already growing list of legal challenges. The Supreme Court revealed that a covert investigation has been underway the entire time, one involving evidence so sensitive, so potentially consequential, or so deeply intertwined with national security that even the existence of the subpoena was kept classified. The fallout from this sudden disclosure is poised to radically reshape everything we thought we understood about Trump's legal vulnerability and his political trajectory moving forward. To fully comprehend the magnitude of this surprise ruling and why it has unleashed such widespread turmoil, it is crucial to understand just how extraordinarily rare this type of Supreme Court action truly is. Under normal conditions, the Supreme Court stands as the ultimate symbol of judicial transparency. Cases appear on public dockets. Oral arguments are scheduled months in advance. Legal briefs are filed openly, allowing journalists, scholars, and the public to scrutinize every detail. Secrecy is almost entirely absent from the court's standard operations. Yet the court does retain the authority, in exceptionally rare and narrowly defined circumstances, to conduct proceedings entirely under seal. This extraordinary power is reserved for situations involving grave national security concerns or other critical interests that demand absolute confidentiality. Historically, this authority has been exercised sparingly, typically limited to cases involving top-secret classified material, active intelligence operations, or scenarios in which public disclosure could cause immediate and irreversible harm to the nation. That the court chose to invoke this power here underscores the seriousness of what is at stake. According to the ruling released on December 7th, this sealed process began more than a year ago. It was triggered when a grand jury issued a subpoena demanding Trump's financial records, internal business communications, and documents tied to what the opinion cautiously describes as matters of profound national significance. Because the subpoena was issued under seal, Trump was served while simultaneously being placed under a strict gag order. He was legally barred from disclosing its existence to the public, his political allies, or the media. His attorneys were bound by the same uncompromising confidentiality restrictions. And here's the twist that makes this story almost surreal. Trump challenged the subpoena through sealed court filings, deploying the same familiar defenses of presidential immunity and executive privilege that he has repeatedly asserted in open court. He leaned heavily on his well-worn legal playbook, but this time it collapsed. The case moved through the federal judiciary entirely out of public sight. The trial court dismissed his arguments, the appellate court did the same. And now, the Supreme Court has delivered the final blow, rejecting his claims outright, revealing the existence of the hidden legal battle, and ordering immediate compliance. The opinion authored by Chief Justice John Roberts is direct and unsparing. It states that the subpoena targets materials tied to conduct that falls wholly outside any credible assertion of presidential immunity. The ruling further notes that the defendant's efforts to delay, resist, and obstruct compliance have been fully litigated through proper legal avenues, and that no further postponements will be tolerated. Legal experts analyzing the ruling note that its language suggests this investigation is entirely separate from the classified documents case in Florida, separate from the January 6th prosecution in Washington, and separate from the Georgia election interference racketeering case. This appears to be a distinct and independent front, effectively a fourth major legal battlefield that opened beneath Trump without the public ever realizing it existed. It is true that this is not the first time the Supreme Court has ruled against Donald Trump. He has absorbed losses before. What makes this decision fundamentally different is the element of total surprise and the sudden exposure of a legal front that had remained completely hidden. When the court rejected his claims of absolute immunity earlier this year, his legal team was prepared. That case unfolded in plain sight. They had months to anticipate the outcome, refine fallback arguments, and coordinate a public response. The ruling was damaging, but it was not unexpected. When the court ruled in 2020 that New York prosecutors could obtain Trump's tax records, there was no sense of shock. That fight had played out publicly for years, giving his attorneys ample time to plan for every possible consequence. Even the landmark Watergate decision in United States versus Nixon, which compelled a sitting president to turn over the White House tapes, followed a prolonged and highly visible legal battle. Richard Nixon knew the case was coming. He understood the stakes. He had time to weigh his options, including resignation. This ruling is different in its very structure. Trump's team had no awareness that this sealed proceeding had advanced to this stage at the appellate level in this form. They had no opportunity to brace for this outcome on this specific day. They began the morning believing they had a complete understanding of Trump's legal exposure. By midday, that assumption had collapsed. According to reporting from the New York Times on December 7th, Trump's lead attorneys learned of the decision through breaking news alerts rather than formal notification from the court. Because the case was sealed, even routine procedural communications were tightly restricted. One source described the atmosphere at Mar-a-Lago as pure chaos, with lawyers scrambling to identify which documents were covered by the subpoena and how rapidly compliance would be enforced. And this brings us to Trump's familiar response pattern. When confronted with setbacks, he goes on the offensive. After the immunity ruling, he attacked the justices themselves. When lower courts ruled against him, he rushed to file appeals. When damaging evidence emerged in the classified documents case, he dismissed it as fabricated or politically motivated. His approach has been remarkably consistent. Attack the process, stall for time, and attempt to undermine the legitimacy of the ruling institutions. This decision leaves virtually no space for that strategy to function. The subpoena has already been challenged at every level of the federal court system. The Supreme Court's ruling is conclusive. There are no remaining appeals. There is no higher body to turn to for relief. The decision sets a firm compliance deadline of precisely 72 hours from the moment it was issued. This is not a matter of weeks. It is not even a matter of days. It is 3 days total. The court also issued an unusually stark warning. The opinion states that any failure to comply fully, promptly, and in good faith will trigger immediate civil and criminal contempt proceedings, with potential consequences that include pretrial detention. In plain terms, the court is signaling that any attempt to delay, obstruct, or submit partial or evasive responses could result in incarceration before a trial even begins. This language reflects a judiciary that has reached the end of its patience. The justices have observed repeated attacks on judges, defiance of court orders, and the use of the legal system as a political spectacle. With this ruling, the court is making clear that such conduct will no longer be tolerated. Before we examine what these documents may contain and why they are so dangerous for Trump, take a moment to support this channel. If you value detailed analysis that explains the reasons behind the headlines, press the like button now. Leave a comment sharing your perspective. Do you think Trump will comply, or will he risk outright defiance? Share this video with friends and family who need to grasp the gravity of this moment. Engagement is the only way this critical information reaches a broader audience. So, what exactly does this sealed subpoena demand, and why has Trump's legal team reportedly descended into chaos? The answer lies in the extraordinary scope of the requested documents. According to excerpts now made public, prosecutors are seeking 3 primary categories of evidence. First, they are demanding complete financial records from Trump's business empire going back to 2015. This encompasses every transaction involving foreign entities, all loan agreements along with their detailed terms, and every communication related to property valuations. These documents strike at the heart of long-standing allegations of financial misconduct and potential money laundering, claims that have shadowed Trump for years but have never been fully tested in court. Second, prosecutors are demanding all communications between Trump and certain foreign nationals whose identities remain redacted for national security reasons. This goes far beyond routine business interactions, hinting at potential contacts with foreign governments or individuals tied to intelligence networks. Analysts speculate this could range from dealings with Russian oligarchs to undisclosed communications with foreign officials during or after Trump's presidency. The third category is arguably the most explosive. The subpoena requests documents connected to efforts to obtain anything of value from foreign sources in relation to electoral activities. This closely mirrors federal laws that prohibit foreign contributions to U.S. political campaigns, suggesting investigators may be probing whether Trump or his campaign solicited or accepted illegal foreign assistance, a claim that strikes at the heart of democratic principles. This is where Trump's legal defense faces an almost insurmountable challenge. These requests intersect with existing investigations, but go far beyond them. Financial records may overlap with known civil fraud cases, yet they could also reveal entirely new conduct not previously charged. Communications with foreign nationals might touch on prior inquiries, but the national security designation implies far more serious implications. Trump's attorneys have only 72 hours to gather and produce documents spanning nearly a decade of complex business and political activity. They may not even know where all relevant materials are stored. They must review potentially millions of pages for privilege issues while knowing the court has made clear it will accept no delays. Sources speaking to Politico on December 7th reported that Trump's legal team held an emergency meeting within hours of the Supreme Court ruling to confront what one attorney described as an impossible task. The volume of documents is staggering, the timeline unforgivingly short, and the penalties for non-compliance could include imprisonment. Yet the logistical burden is only part of the danger. The far greater threat lies in what these records may reveal. What Trump fought so aggressively to conceal over a year of secret litigation now teeters on the brink of exposure. The extraordinary secrecy surrounding this investigation strongly indicates that prosecutors consider the evidence potentially devastating. Multiple reports, including coverage from CNN and MSNBC, describe Trump's reaction to the ruling as explosive. Sources say he shouted at his attorneys, threw objects, and demanded to know who allowed this secret proceeding to continue unchecked. There was no betrayal. His lawyers had vigorously contested the subpoena and lost at every stage in cases they were legally barred from discussing publicly. The very secrecy Trump often uses to control narratives turned against him. He could not rally public support for a battle the public didn't even know existed. Unsurprisingly, he escalated the situation. Within hours, he posted on Truth Social, attacking the Supreme Court justices, including those he himself appointed, calling the ruling a covert assault by corrupt judges. He suggested Chief Justice Roberts was compromised and declared the entire proceeding unconstitutional, explicitly stating he would not comply with what he described as an illegitimate order. Legal experts immediately raised alarms, warning that these statements could serve as compelling evidence of intent to defy a lawful court order. If Trump follows through on his threat to refuse compliance, prosecutors can point to these social media posts as clear proof that his non-compliance was deliberate and intentional, not the result of logistical hurdles or good faith disputes over the subpoena's scope. Former federal prosecutor Andrew Weissman, speaking on MSNBC, noted that Trump's public remarks essentially amount to a written invitation for contempt proceedings. Weissman explained that when a defendant openly declares an intention to ignore a Supreme Court order, prosecutors do not need to prove intent. The defendant has already done it publicly. This situation places Trump in a catch-22. Every possible course carries serious consequences. Complying with the subpoena means handing over documents that could expose entirely new areas of potential criminal liability. Whatever he has worked to conceal over the past year is now poised to enter the official record. If Trump refuses to comply, he faces immediate contempt proceedings. The court has already made clear that potential penalties could include pretrial detention. In that scenario, he could end up behind bars, not for crimes he has been formally charged with, but simply for failing to obey a lawful subpoena. The spectacle would be historic: a former president jailed for contempt while multiple criminal trials remain pending. Any attempt to delay through procedural maneuvers is virtually impossible under the 72-hour deadline. There is no time to file new motions. There is no opportunity to pursue additional appeals. The Supreme Court has spoken. The decision is final. Compliance is mandatory. It is a trap with no way out, and it is entirely of Trump's own making. Whatever these documents contain, he could have turned them over a year ago when the subpoena was first issued. Instead, he fought the order at every level and lost repeatedly, consuming time and resources while keeping the evidence out of prosecutors' hands. Now, no viable options remain. This revelation is sending shockwaves through Trump's political and legal circles. The disclosure of a previously secret proceeding has sparked urgent concerns about what else might be unfolding behind the scenes. According to the Washington Post, on December 7th, Trump's allies are reportedly in near panic, scrambling to determine whether additional sealed proceedings exist that they have not yet been informed of. If one confidential investigation could reach the Supreme Court without public knowledge, why could others not exist as well? What additional matters might the Department of Justice be pursuing that have not yet been revealed? This uncertainty is psychologically devastating to Trump's defense strategy. For months, Trump's attorneys structured their strategy around the cases they believed were publicly known. Classified documents, January 6th, Georgia, and New York. They allocated resources, designed legal tactics, and coordinated timelines under the assumption that they fully understood Trump's legal exposure. They now realize that assumption was dangerously incomplete. The situation grew even more chaotic when reports surfaced that at least 2 attorneys on Trump's team are considering stepping away from the case. According to sources speaking with CNN, these lawyers were not fully briefed on the sealed proceeding due to strict confidentiality rules. They are now grappling with whether they can ethically continue representing a client who may have withheld critical information, or expose them to potential ethical violations. Attorney withdrawal at this stage would be catastrophic. Any new counsel would require months to get up to speed, yet the 72-hour compliance deadline does not pause for staffing changes. Trump's already strained reputation within the legal community also makes it extremely difficult to find qualified replacements on short notice. Meanwhile, the attorney who previously cooperated with prosecutors, the individual responsible for providing the leaked audio recordings, is reportedly offering additional insight into the sealed subpoena. Sources familiar with the matter, cited by Politico, indicate this cooperating witness has detailed knowledge of documents Trump attempted to conceal and can testify about conversations in which Trump discussed the consequences if those records were ever made public. If accurate, this means prosecutors possess more than mere subpoena authority. They have a precise roadmap. They know exactly what to look for and can immediately spot any discrepancies or missing materials when comparing Trump's production to what the cooperating witness has described. This raises broader questions about what this surprise ruling means for Trump's overall legal exposure, as its implications stretch into areas that have not previously been explored publicly. The demand for extensive financial records suggests prosecutors are building a case that goes far beyond the current fraud allegations. The New York civil fraud case primarily targeted inflated property valuations for loan and tax purposes, but the scope of this subpoena, covering records dating back to 2015 and encompassing all foreign transactions, indicates a far deeper investigation. Legal analysts are now speculating about potential money laundering, unreported foreign income, or violations of the Foreign Corrupt Practices Act. Tax law experts speaking with CBS News describe the breadth of the financial records request as unprecedented. Prosecutors typically narrow subpoenas to specific transactions or limited time periods. Requesting all records since 2015 involving foreign entities signals an effort to uncover patterns of systemic behavior rather than isolated incidents. Second, the demand for communications with redacted foreign nationals raises significant counterintelligence concerns. The court's reference to national security as the reason for sealing these identities is far from routine. It suggests that these individuals could be connected to foreign intelligence services or may themselves be subjects of ongoing national security investigations. Some legal experts are linking this development to long-standing questions about Trump's interactions with foreign governments, his unusual deference to Vladimir Putin, private meetings with foreign leaders without U.S. officials present, and his handling of classified information in communications with foreign nationals. These issues have never been fully resolved, and the subpoena may finally produce documentary evidence capable of clarifying them. Third, the request for documents related to obtaining items of value from foreign sources in connection with electoral activities points to an investigation into potential campaign finance violations on a scale far beyond anything previously disclosed. Federal law strictly prohibits foreign nationals from contributing to U.S. political campaigns and forbids campaigns from soliciting or accepting such contributions. If Trump or his campaign did receive foreign financial assistance, it would constitute a serious federal offense. According to campaign finance experts interviewed by MSNBC, the specific language used in the court's ruling closely mirrors the statutory prohibition itself. They emphasize that prosecutors do not choose such precise wording accidentally. It indicates they may already possess evidence of potential violations and are seeking documents to confirm or expand the case. Taken together, these three areas, financial records, foreign communications, and potential evidence of foreign campaign support, suggest an investigation far more serious than Trump's existing criminal cases. This goes beyond mishandling documents or attempting to overturn an election. It touches on possible corruption at the intersection of wealth, foreign influence, and the very integrity of American democracy. Legal scholars are already weighing the constitutional and historical significance of this ruling. Lawrence Tribe, the renowned Harvard constitutional law professor, noted on social media that this decision may be the most consequential Supreme Court action involving a former president since United States v. Nixon. He added that while the use of a fully confidential procedure is extraordinary, it appears to be warranted by national security considerations that may remain unclear for some time. The judiciary has now made it clear that confidential grand jury proceedings can reach the Supreme Court and produce binding rulings even against former leaders. They have demonstrated that claims of protected authority and presidential privilege, even when vigorously asserted, can ultimately be overruled when the material sought relates to actions outside the scope of presidential duties. This sets a powerful precedent. Future office holders will understand that their conduct can be investigated in secrecy, that legal disputes can be resolved away from public scrutiny, and that compliance can be enforced swiftly once the courts issue a final decision. The era in which public attention and stalling tactics serve as primary defenses appears to be drawing to a close. Furthermore, the national security dimension of this ruling raises serious questions about what government security agencies may know regarding Trump that the public does not. The fact that these proceedings were conducted in secret suggests the information is so sensitive that even revealing the investigation's existence could cause harm. What exactly do prosecutors know? What have national security agencies uncovered, and how long have they possessed this knowledge? These questions may never be fully answered, or at least never disclosed publicly, but they underscore the extraordinary significance of this case. We are not only examining a previous leader receiving criminal allegations, we are examining possible hazards to national protection that necessitated confidential judicial processes to manage. Considering the governmental aspects ahead, the judgment generates substantial unpredictability. Trump presently occupies the primary position for the Republican Party's leadership selection. He campaigns centered on opposing the corrupt institution, allegedly attacking him. However, this judgment demonstrates that the institution has examined him in manners he failed to recognize, and that examination has currently achieved a level where obedience is required. What was Trump's group's reaction? Certain individuals will consider it proof of persecution by an underground governmental force functioning covertly. Still, others might begin asking themselves what their hopeful leader has concealed. What creates such destruction that he battled a confidential court struggle entirely toward the Supreme Court to maintain it hidden? According to the latest reporting from YouGov,